around the impact that Dr. Nujoma had as far as constitutionalism, lawmaking, and the law as principles are concerned. Professor Dunia Prince Zongwe, Associate Professor of Law at the University of Namibia, this past week reminded Namibia that the late founding President Sam Nujoma was the father of the Constitution. According to Zongwe, the founding president had the responsibility to implement the fundamentals of the supreme law of the land in his capacity as the inaugural head of state of the Republic. Now, to further cement both our individual and collective understanding of Dr. Nujoma's role in relation to law, we have invited an esteemed panel, Windhoek-based legal practitioner, Madam Monika Angula. Good afternoon to you, ma'am, and thank you so much for making time for us.
Thank you for having me.
We have also invited renowned social justice academic, Dr. John Nakuta. Greetings to you, doctor, and thank you so much for making time for us.
Thanks for the invitation, Denver.
Last but not least, we're joined by another Windhoek-based legal practitioner, Mr. Afrika Jantjies. Good afternoon to you, sir, and thank you so much for making time for us.
Thank you for having me. Always a pleasure, Denver.
Madam Angula, let's please get straight into it. From your perspective, if we're talking in broad terms, we will get into more particulars during the course of our conversation this afternoon. What do you believe was Dr. Nujoma's most significant, most impactful contribution to the legal ecosystem in what we call Namibia?
Dr. Sam Nujoma was such a hands-on person, and he contributed immensely to the legal landscape and ecosystem of the Namibian nation. In fact, in terms of constitutional development, he played a pivotal role as he chaired the first meeting that was held with the drafting of the whole constitution. With regards to national policy, Dr. Sam Nujoma was also the one who adopted and implemented the reconciliation policy, where he attempted to basically mend the wounds that apartheid had towards the Namibian nation. Another thing Dr. Sam Nujoma also really was passionate about was human rights, and more in particular the advocacy of women's rights. In fact, Dr. Sam Nujoma advocated the laws that were required with regards to maintenance of children. He was actually very passionate about it, as well as equal rights for all men and women within the Namibian landscape. Another thing is the environmental legislation. Dr. Sam Nujoma also provided, or rather spearheaded, the fact that all national resources should benefit the Namibian nation. So those were the areas that I feel that he contributed immensely and made vested efforts to really ensure that the Namibian nation worked together and that everything that was here was for the benefit of its people.
Thank you for those insights. Dr. Nakuta, from your perspective, what would you deem to be the most significant, most impactful contribution on the part of our late founding president as far as the legal ecosystem of this country is concerned?
Yes, now thanks for the question, Denver. For me, President Nujoma's influence on our legal system is best captured in Vision 2030. Remember, Vision 2030 was launched in June 2004 by the very person that we are celebrating today.
During his second last year in office.
Exactly.
Yeah.
And without diluting, I don't want to dilute, and let me just capture the essence of what Vision 2030 is saying. It envisions a legal system that is aimed to transform the legal system by creating a more accessible, efficient, and equitable justice system for all citizens, with a focus on strengthening the rule of law, addressing historical injustice, and improving access to legal services, particularly for marginalized communities, while all promoting transparency and accountability. For me, that captures the document that foresees and envisions a legal system that adheres to some of these principles. Of course, it is one thing now, I suppose, during this times, it is time for us to reflect, is this really the system that ultimately the likes of founding President Nujoma really had in mind, where are the gaps? So that's one thing. But also for me, very importantly, during his first term of office, founding president signed up to all major international instruments.
Why is that significant?
Very significantly because, and she mentioned, in fact, the very first one that goes to the heart of the person that we are celebrating, in 1990, and if I'm not mistaken, in September 1990, we signed up to the Convention on the Rights of the Child. And everyone knows that Tate Nujoma had children close to his heart. The second important one, and again she spoke to that, the second major international instrument that we signed up to in 1992 was the Convention on CEDAW, that is the Convention on eliminating all forms of discriminating against women. And then here comes the big one, the International Bill of Rights, which includes the ICCPR, which stands for the International Covenant on Civil and Political Rights, and then also in 1994, the International Covenant on Economic, Social and Cultural Rights. And for me, this is significant, and it goes to what you were saying, that someone that believes in equality and justice and human rights for all. So we should celebrate this.
Thank you, Dr. Nakuta. Mr. Jantjies, from your perspective, which do you deem as the most significant, most impactful, most pertinent contribution on the part of Dr. Nujoma regarding the country's legal ecosystem?
Thank you, Dan. Well, I think what is quite important is you can never isolate or never alienate the historical context in which our laws evolved, and also appreciate, as part of the architects of our Constitution, what role the Constituent Assembly was tasked with. Taking into account that Namibia transcended from a colonial regime, from an apartheid regime, where you had martial laws, where you had various other discriminatory laws, where you had laws that were embedded on segregation, and where the Constitution was absent. One of the hallmarks of the Constituent Assembly, when this consensus mechanism, insofar as discussing the text of the Constitution and what it should incorporate, was also predicated on what the Western Contact Group had proposed to be incorporated, which was the constitutional principles. And those constitutional principles, Dr. Nakuta had just alluded to, also involved the following. That involved that Namibia would be a sovereign state, it would be a unitary state, it would be a democratic state, which will establish 3 branches of government, that being the executive, the legislative, as well as the judicial. The judicial obviously being independent, and the legislative, the lawmaking body, as well as then the executive being the executive. In that very same constitutional principles that were adopted, in fact, they were adopted at the first constituent meeting, and there was always this suspicion at that time as to being a socialist party, whether the majority party at the time would rather incorporate socialistic values, socialistic principles, and of course there was an attempt to dictate what the Constitution should look like and its text should read. And it shouldn't look like. And there were various groups, obviously for various interests, and I think for purpose of this discussion, the constitutional principles then set the trajectory of constitutional values. And part of those principles, apart from being a sovereign, Namibia will be a sovereign country, a unitary state, and will have its 3 branches, it also then adopted the Universal Declaration of Human Rights, which had to be consistent with the UN declarations and incorporating that into the Constitution as well.
Mr. Jantjies, can we pause for a moment? Dr. Nakuta was sharing with us that it is a time for reflection.
Yes.
Particularly within the context of Vision 2030, but also in the context of the death of the founding president. The extent to which we have sufficiently internalized those ideals, also as expressly provided for in our Constitution. And in 2025, we can honestly and with conviction say that we're owning up to those aspirations, we're owning up to those hopes that had been expressed under the leadership of the late founding father.
Definitely, and I think in highlight, Vision 2030 is, again, as reflected and as encapsulated, its genesis derives from the constitution that eventually was adopted. And it's a very important discussion because, remember, the constitution is one of the essential qualities of the constitution is it places limitations on government. And it ensures that you have avoid arbitrary rule, arbitrary arrest, arbitrary conduct. But more than that, it sets a legal document which is regarded as the supreme law, which is sui generis, which is not subservient
Please
to any
tell
other
the
law.
layperson what sui generis means.
Well, it's autonomous. There's no other law above it.
It's supreme.
It's supreme in its
Yeah,
nature. And
thank
I
you.
think it's important to appreciate it from the context of saying we've got a constitution that not only requires its citizens, but also creatures of statutes, organs of the state to subscribe to.
Thank you.
It sets the pathway, it sets the parameters, it sets the framework. And one of the essentials is that it has then these various provisions inside, which, again, for me, ultimately, quite importantly, is the Bill of Rights, which reflects our society in broader context of, everyone is equal before the law. You'll not be subjected to arbitrary arrest, arbitrary detention,
Thank you,
the
Mr.
right to
Jantjies.
life and all of that.
Thank you very much. Madam Angula, as we continue to reflect on the founding president's contribution to constitutionalism and lawmaking, is it your conviction that we've sufficiently internalized those ideals? You've highlighted a very particular example that Dr. Nakuta also emphasized, namely gender equality and also the rights of children. But have we, in 2025, sufficiently internalized those ideals and those hopes, those aspirations, that we can say we're proud as a nation to do justice and to honor his legacy?
Yes, we have. But we should also take into consideration that we are still a very young state. But we were fortunate enough to have a president, a founding father, that really set the foundation for all of us and for future presidents that came after that. He really, like I said, had a very hands-on approach. Dr. Nujoma was the chairperson of the first meeting that was held with regards to the drafting of the Constitution on the 21st of November 1989. He was there. He ensured that whatever scars and wounds had resulted in the apartheid era were going to be corrected going forward. And by doing so, the best way forward was, like Mr. Jantjies said, developing a constitution that is fair and that canvasses democracy to such an extent that it really is for the benefit of all people. And really today, there is a conviction within us, because even today, we still echo the sentiments of Dr. Nujoma back then with regards to land reform initiatives. That is also something that was very close to his heart. With regards to the advocacy of social justice, that is also something Dr. Nujoma advocated for, as well as national reconciliation. And if that wasn't true to us, we would certainly have reverted back to the past, and we haven't. We learn every day. We learn from our mistakes. And like Mr. Jantjies said, we have a constitution that actually does put the government, it poses a certain level of accountability towards the government, So if there's civil rights or human rights that are being infringed, that can be challenged. That is a democratic state. And that is what Dr. Nujoma always wanted.
Avenues for recourse exist.
Yes.
Yeah.
So I think now that he has left us, I think we have peace in knowing, or we can, although we are mourning, there's a sense of pride in, like, we are really the state we always thought we could be, and we're still moving into that direction.
Thank you so much. Dr. Nakuta, we sat down earlier with President Nujoma's nephew, the former government attorney, Advocate Mati Asino, who said that it was such a privilege to witness his uncle when a judgment was passed by our courts that wouldn't favor the government of the day. His uncle would say, but we need to respect that. So he had that personal experience of how the then head of state honored the separation of powers. I want us to please talk about how his approach to leadership crystallized the principles of the independence of the judiciary and certainly shaped the rule of law and also enhanced access to justice in a post-independent Namibia.
Yeah, I can think of 3 examples very briefly. The first one that came to my mind when I was preparing for this is that we all know that founding President Nujoma and also the late President of Zimbabwe, Robert Mugabe, had a close relationship. And what impressed me back then was the fact that President Nujoma made it clear that the kind of land expropriation that happened in Zimbabwe will not happen in Namibia. And that for me was very crucial because our constitution is clear, expropriation yes, but with against fair and just compensation.
However problematic or complex that might be.
And here comes what you say, his nephew said, respecting the rule of law. Way back, under his leadership, the first expropriation of absentee landlords happened in the Castle case. In that case, the High Court found that the government, in as much as you have the power to expropriate as authorized by the Constitution, there are certain procedures. And the expropriation procedures as laid down in the piece of legislation was not followed. And government abided with that Constitution. So for me, that is very important. Another one in terms of access to justice. Remember, I've mentioned that we've signed up to the International Covenant on Civil and Political Rights. Somewhere in the late 90s, we had the unfortunate situation that happened in the former Caprivi region. People took up arms and they wanted to secede the Caprivi region from Namibia. We know the history. The 128 accused people that face over 295 counts against them, they applied for legal aid. By the way, legal aid is not a constitutionally guaranteed right in Chapter 3.
Not expressly provided for, at least.
Yes, it is only provided for as a principle of state principle in under 95, which is unenforceable. And so the government attorneys said that no, in Namibia there's no such thing as a right to paid legal aid. The High Court said that you've signed up to the International Covenant on Civil and Political Rights, which provides for the right to paid legal aid. And the government was ordered to provide legal aid.
Which it subsequently did. Yeah.
And they appealed. But the point of respecting the independence of the judiciary, the government, under the leadership of Tate Nujoma, abided to that. The 128 accused persons has been provided up until today with paid legal aid. For me, that is crucial.
Not without significance. May I be mischievous at this juncture, Doctor? Would one be able to infer under the, equality for all before the law that right to legal aid could be read into that?
Can you repeat the question again, sorry?
If we have regard to everyone being equal before the law, would one be able to infer under that you must have access to legal representation?
Oh, yes, of course.
And by implication, if you're not able to afford it,
yes,
paid for by the state.
Exactly.
Yes.
Because you remind me of a very important principle in human rights law. The notion of indivisibility of rights. Rights are interconnected. I make the example in my classes. It's like the Bill of Rights in our Constitution doesn't provide for the right to adequate housing. It's not guaranteed in Chapter 3. But can you say that the person that is living under the bridge, that is homeless, is living the kind of dignified life guaranteed in Article 8 of our Constitution.
And expressly referred to as inviolable.
Exactly.
Such dignity. Thank you, Doctor.
So your point is fine. It's like, in as much as the right to legal aid is not expressly provided for, it can be read into our Bill of Rights through the right to equality.
Very well. Mr. Jantjies,
Yes.
so much has been said in terms of practical examples. I think the Zimbabwe versus Namibia example is quite a significant one, and the same relates to access to legal aid, access to paid for legal representation. From your perspective, how did Dr. Nujoma's contribution to the rule of law find practical impact in this country?
Well, my learned colleagues have just highlighted very practical examples as to how during his leadership, he contributed and significantly ensured that you had laws that advanced the cause of Namibia, be it through the Married Persons Equality Act. Prior to that, women could not sign, or women were limited and restricted in terms of loans. And I think there are various examples that were given as far as also the approach to land expropriation. And if you look at the fair and just aspect in terms of compensation, that already found its place during the Constitutive Assembly when that consensus mechanism took place, and it was part of the general principles that were adopted. And upholding the Constitution, protecting the Constitution, and allowing the Constitution to dictate every aspect and social fabric of our society and life. And upholding not only those principles, but ensuring that you have the adequate separation of powers, checks and balances, democracy, which are all indispensable elements of constitutionalism. You cannot isolate them as such. But just coming back, I think quite importantly is that being part of the architects of our Constitution and having crafted and deliberated in terms of the text and in terms of what Namibia should embrace, one of the critical elements, and I discussed this with my students as well, is that unbeknown perhaps, and my learned colleagues might also jump into this, is perhaps Namibia pioneered transformative constitutionalism. Because before South Africa could even, in their constitution, adopt that, one of the considerations that Namibia took was take into account the racial background in terms of apartheid, that whole racial stratification, the whole oppression, and to ensure that the Constitution of Namibia will adequately address all the injustice of the past, all the imbalances of the past.
By implementing corrective measures.
But implementing corrective measures, and that's why you would have affirmative action, and the debate would have always been, is affirmative action corrective, is it punitive, does it seek to readdress the injustices of the past? But these were all instruments that eventually emanated from this document called the Constitution. And we should never undermine its significance and what it means. Does not matter in what role we find ourselves, whether as, again, an organ of the state, whether a creature of statute, whether a regulator, whether a law enforcement. The Constitution does not just guarantee certain rights. It is the instrument, it is the law that everyone is subservient to or accounted to.
Even a head of state.
Even the head of state.
Yeah.
And it gives you and again, remember, the Constitution is not an act of government. It is an act of the people to constitute a constitution.
Thank you. Thank
Yeah.
you. Madam Angula, in your introductory overview, you made mention of a critically important example. Dr. Nujoma also cared very deeply for children, and he saw to it that minor children get maintenance. What we do know is discrimination was specifically against children who were born out of wedlock, and how they didn't receive maintenance, and it, to some extent couldn't inherit. Talk to us about, through his leadership and through his guidance and through this constitutional democracy, we saw to it that even those whom we deem to be minors and deemed to be children are regarded as important citizens of the country.
Yes. Dr. Sam Nujoma loved children. You could see at all of his events, he had a deep desire to see the children, and he always emphasized that the children are the future of our nation. And it is correct that because of the frameworks, the laws that he set in place, we have now abolished acts that, or rather practices that disallowed what was termed illegitimate children from inheriting from their parents, you know. Dr. Sam Nujoma also worked at the traditional practices, you know, when the traditional marriages are valid under our constitution, and the discrimination against not only children but also the widows of those of the particular traditional families that were being affected, and also promoting the legal protections for the vulnerable populations. So today we see like Mr. Jantjies said, the laws are constantly reforming, and the Constitution allows for that reformation, that corrective aspect to it as we grow as a nation. Because now you see that the Child Care Protection Act has been implemented. It safeguards not only the rights of the mother, but now the father. Before that, it was just the mother that was, you know, that had majority of the rights, perhaps, over the children. The inheritance law, adopted children as well. They're basically, they stand in the same position that a child born, whether in or out of wedlock, would. And these are all things in terms of inheritance, equal employment opportunities, affirmative action. It's such a great cycle to see, because you see a marrying of all of these laws that not only protect any and every other citizen, but children. The heart of Dr. Sam Nujoma. And it's very nice to see within this day and age of Namibia.
Thank you. Dr. Nakuta, the national policy on reconciliation has been mentioned a couple of times. How, despite the violent past, Dr. Nujoma's stance was that we need to include all and forgive. And there was a sense that at the time many didn't agree with that, or many thought, yes, we can forgive, but we can't forget. But against the backdrop of human rights, why was that so critically important for the ultimate success of this democracy?
Now, obviously, the notion of reconciliation is very important. I'm just coming from a public discussion where one of my colleagues was like saying that one of the primary obligations of the state is to maintain law and order, and that no chaos must, that no proper state can function within a state of chaos. So now imagine if we did not have a policy of national reconciliation, would we still have the kind of peace and stability, our greatest export commodity, that we have today? I would say no. But with all due respect, I would fail in my duty and in my conscience if I were to say that in as much as we have a policy of national reconciliation, there are some serious deficiencies that I at least would want to point out. And as a time of reflection, that maybe it's also necessary to do this. There's at least two that comes to my mind. We've got a piece of legislation on our law books that explicitly exclude those that fought on the wrong side of the law. And I'm here talking about the Swati Fs and the Kufuts. Now, if you talk about reconciliation, how can you have a system that expressly, and I know the political leadership thinks otherwise, but expressly exclude those ones? And I'm not talking about hero status, because they were not our heroes. But in terms of social benefits, a pension, for example, that as a veteran, in fact, the Veterans Act has coined our own definition of what a veteran is. Internationally, in any international dictionary, a veteran is someone that has fought in a war. In our system, a veteran is someone that has fought on the side of liberation. And that is discriminatory. And maybe that it gives us time to do some serious introspection in terms of who qualifies for veterans' benefit and not for hero status. That is one. The second one is also going to the notion of reconciliation. Again, with all due respect, and we understand it was a war situation. And there's this notion that there were people, not even notion, there people have written about it, people came out, and they spoke about the Swapo dungeons, the torture that happened in there. And if we talk about healing the wounds, we can't say let bygones be bygones. In fact, in conclusion, which is also against the principles of human rights, and the international human rights bodies has shed serious concerns about it. In 1988, we have signed, is it 89 or 89? I'm not so sure with my facts. We've signed a blanket amnesty that says on both sides, for those ones that fought in the war, on both sides, no one will be prosecuted.
Thank you, Doctor.
Now, blanket amnesty is inconsistent with accountability and respect for human rights.
Thank you, Doctor. Mr. Jantjies, you and I can practice our professions. You and I can associate. You and I can form organizations and institutions. Help us understand the role that Dr. Nujoma's administration played in establishing legal institutions, but also capacitating the legal profession.
I think quite importantly, one of the organizations or one of the bodies that were established, and I think my learned colleague Monika mentioned in terms of law reform, is the Law Reform Commission. And its primary objectives was also to ensure there's laws that are reformed, because inherently you would appreciate that when we transitioned from a parliament sovereignty to a constitutional democracy, to constitutional dispensation, you still had very archaic, draconic apartheid laws that did not necessarily serve the ideals, the aspirations, the values of a post-colonial Namibia. And I think if you look at bodies such as that, which continuously look at laws that were discriminatory, look at laws that, were marginalizing and of course not serving the interests of Namibians. And again, in upholding these institutions, these were key pillars in ensuring you have a nationhood that embraces not only principles but have practical effect and practical meaning towards that. And I think his leadership was not just from a revolutionary, a visionary, a liberator, but also within the fabric of Namibian society, that institutions that are catalysts, institutions that are designed to ensure that the constitution in itself can be implemented in all its facets. And again, one of them, as I said, would have been the Law Reform Commission. You would have at other different commissions that would have been established to have regard and look at different aspects. But I think for me the most significant would have been that. I think given also that you have a legal dispensation that still heavily relies on laws that are not necessarily Namibian laws, but that we apply in Namibian courts. And at the advent of independence, they could have said, well, any other law that is not Namibian laws, we're going to create our own laws. But they chose not to do that. And they
Would we have had that right as a sovereign state to do that?
Well, again, the conventional that discussed and had this mechanism considered all aspects. And one of them was, of course, what do we do with the existing laws? Do we then disregard them? Or would we establish a legislative body that would draft new laws? And would we have then statutes that would dictate how we deal with these other laws? And I think that in itself was one of the hallmarks of the founding father. Of course, it was a collective. It was him leading, influencing, but again, as the executive making decisions, sound decisions that were driven by consultative input, but also having regard to where Namibia comes from, but where Namibia was heading towards. And just coming back to your question and saying, look, we can freely practice our profession, we can associate, and I think this is quite important, because some of these were limitations that you had under apartheid. And the same limitations that Namibia had, then being Southwest Africa, were the same limitations it had, or the equivalent experience that South Africa would have had. So Namibia emerged from a real apartheid administration, that really at the fullest applied the apartheid policies, the apartheid laws. And one cannot, almost imagine them away in having a context when you talk law, constitution, reform, the impact and different advances that were made. And so when we find ourselves in post-colonial Namibia, in post-independence Namibia, where we have the liberty to even challenge electoral outcomes, the law makes provision for that. In other countries, and and we often say Namibia is one of the best democracies in the world. Namibia, has a functional democracy. Namibia has a functional constitution. It has meaning, it has effect. It's not a piece of paper that is there.
Thank you,
and
sir.
that symbolizes the fabric and the contribution of Dr. Sam Nujoma.
Thank you, Mr. Jantjies. Madam Angula, I want us to briefly return to the doctrine of separation of powers. Some say that inasmuch as it is a noble pursuit, it's challenging in practice. Judges are appointed by the President on recommendation of the Judicial Service Commission. The executive comprises the President and Cabinet. Some Cabinet members are also members of the National Assembly and thus part of the legislature. What is your stance on what the responsibility of a head of state is to ensure that to the best of our ability, separation of powers is upheld, is maintained, is given effect to?
I will then remind you what you just also informed us that Mr. Matthias said when he received judgments, he says, let's respect that. And with all of this, with the Judicial Committee, right, they come by recommendation. Obviously, there's a certain criteria these judges must also adhere to. And that criteria is then obviously given to the President and said, look, we have this particular person. He has this amount of years of experience. He has done this and this and this. And we recommend him to be a judge in the High Court or in the Supreme Court. And based on those recommendations, that is how the President then appoints these judges, obviously, under the guidance of the recommendation, and also to adhere to the law and promote the laws of Namibia. I don't think that is he does something on his own accord. Because if that was the case, we wouldn't even have a commission to start with. We wouldn't even have these recommendations. Then he would nilly-willy decide, even from the street, that, look, you are acting in the High Court tomorrow. So that in itself is a check and balance with regards to that separation of power. And also with regards to the National Assembly, same thing, who is best suited for this particular role? Recommendation. And he, on his own accord, analyzes it and sees what the best interest is of the nation. And I truly and honestly believe that Dr. Sam Nujoma, at all relevant times, always acted in the best interest of this nation. Because look at the recent happenings. The elections are being contested, right? But there was no uproar.
And it wasn't the first challenge of that nature.
It was also not the first challenge. You did not see army generals in the street trying to now incarcerate people for speaking up. And these are all the foundations of which our Constitution has guaranteed to us. That in itself is also a separation of power.
Do we realize how big a deal that is? Do we realize how significant that is?
I think today, at this time, in this time of mourning, and like Dr. Nakuta said, we should really reflect as to how fortunate we are. There's still a lot of African countries where you cannot express yourself the way you want to express yourself. You cannot hold a certain profession like you also indicated. And this is the time where I also indicated that as much as we are mourning, we should be so happy, and we are so fortunate that we were blessed with the presence of Dr. Sam Nujoma. And that, like I said, he laid the foundation so well for all of us.
Dr. Nakuta, what lessons do you believe your students and perhaps young practicing legal professionals can draw from the example of our founding president?
Right. For me, not compromising principles, be principled. Let me just, the because I don't want to lose it.
His decisive leadership has been hailed by many, and once
Exactly.
you take a decision as a leader, even if that's not the popular decision, to take responsibility for that decision. And you're talking about not compromising your principles and decisions that you do take.
Be fearless. And I mentioned, don't compromise on your principles. I love this quote, and you started with it, to serve the common good of humanity. That is what he says, and to detest injustice. But for me, the biggest, for all young people and for everyone else, is, in other words, to challenge the status quo. Especially if the status quo is about injustice. In your programs and what we have learned and what we've read, where others have wavered, at the age of 30, someone decided to take on the mighty South African racist colonial government.
That's no small feat.
No small feat. And it reminds me of something that I read way back, a quote that says, do not think that a few committed people cannot change the world. In fact, it is the only thing that ever did. And through this we know what has happened somewhere in the 60s. A young person that stood up said, I'm going to take them on. Some years later, we celebrated our independence on the 21st of March. For me, that is the most profound message that young students, young professionals, and not just law students, young persons, but for our purposes of our discussion, the legal profession, there's a lot of injustice still in our system. But we should be fearless in terms of not, and I'm now quoting our late third president, not playing the ball, but not playing the
man,
the man,
the ball.
or the woman, but play the ball.
But play the ball.
Yeah.
So
Be fair.
be
Comply
fair.
with administrative justice.
Exactly.
I'm adding on your behalf.
No, it's
Yeah.
exactly the case. And if there is a system, and we've got, for the politicians, we've got the Marriage Act that openly discriminate against a particular section of our community. If we talk about inclusiveness, if we talk about human dignity and human rights for all, we can't make laws that benefit a few to the exclusion of the others. This is not the vision that we are trying to celebrate and to espouse for the future.
Thank you, Doctor. Ms. Jantjies, the fact of the matter also is that avenues of recourse exist. If I claim, as the Nikki saying, that in 2025, this particular law that perhaps emanates from the previous dispensation that we inherited discriminates or is in contravention of the Constitution, an avenue exists where recourse is possible. Talk to us about that and what Dr. Nakuta is flagging, that there are avenues, existing avenues, that we can use to demonstrate fearlessness, but also to demonstrate that change is still necessary.
Well, I think quite important, our Constitution gives you the rights, and those rights, again, without regurgitating and repeating, are not just mere rights for the take. These are rights you cannot derogate from. These are inalienable rights, particularly the right to equality before the law, that you shall not be discriminated against your sex, creed, color, race, religion, and all of that. And that cannot be subject to interpretation or subject to beliefs or dogma or religious, whatever it might be, because we've chosen the Constitution. Now, the courts, being the judiciary, independent organ of the state, are vested then, where you challenge any discriminatory practice, any discriminatory law, any law that's restrictive, inhibitive, any law that you feel takes away your constitutional right. That's why I was placed emphasis on why the Constitution is such an important document. And you can then test this and approach our courts. And our courts obviously have then the independence to interpret the law. But in interpreting the law, my learned colleagues will agree, giving effect to statute, you need to then take into account the Constitution in itself. And you don't just leave it to the courts in itself, but you have the legislative arm, which is also then the lawmaking body. And they too must then embrace the ideals, whether we agree, whether we don't agree, whether we subscribe, whether we don't subscribe. Law evolves, societies evolves. We're not static. We
And the
move.
lawmaking houses, both of them, comprise people we vote into power
That's correct.
in this democratic dispensation.
That's correct. And I think, given what you've just highlighted, where separation of powers, the rule of law, allowing that each organ of the state not only has its own functionary, but that you don't assert too much power or too much concentration where one can overlook or make laws. The courts, the highest courts have pronounced themselves. And now the legislative goes and makes a different law altogether, vitiating the very same laws that, or the pronouncements that are made.
Thank
but
you.
again, we live in a democratic society where you can, you never have an avenue where you say you do not have recourse.
Thank you. Thank you, Mr. Jantjies. As we wrap up our conversation this afternoon, from your perspective, seeing that you have the floor, Mr. Jantjies,
Yes.
your final thoughts as we continue to mourn the death, yet celebrate the life of our founding president and father of the Namibian nation, particularly this afternoon within the context of his contribution to constitutionalism, to lawmaking, and to the law in general.
Thank you so much, Denver. We will never be able to fully articulate his full contribution. I think there are different phases and different immense contribution the founding father has made in different aspects, political, in the legal, and various other aspects. For those that have engaged, worked with him, that have encountered him, they would have experienced his leadership, would have experienced his decisive, not only leadership, but the fact that he advocated for a unity amongst Namibians. He advocated for the respect for the rule of law, and also not just respect, protecting and observing that. And I think that's the legacy we need to celebrate at this point in time. That's the legacy that we need to take forward, and we need to challenge the status quo. You know, if the Constitution makes provision, or the law says you're presumed innocent until you're proven guilty, then that must be it.
By a competent court,
Exactly.
not by Facebook or members of the public.
And therefore, bail cannot be, anticipatory punishment. Bail cannot be seen as a means to say, well, we've got a prima facie case. Bail must then uphold those principles. You can't detain someone for 6 years or 8 years without a trial.
Thank you, Mr.
Because you
Jantjies.
take away that very same presumption, and that is a constitutional presumption.
Thank you.
You know, and just on it, and to give my colleagues a chance, you would see that in other jurisdictions like South Africa, bail is a constitutional right. In our
Expressly provided for. Yeah.
In our jurisdiction, you have the right to apply to bail. But if the presumption is I'm presumed innocent until proven guilty, why am I detained?
Thank you, Mr. Jantjies.
Thank you so much.
I don't want to detain you any longer. Dr. Nakuta, your final thoughts at this juncture?
Yeah, of course I can, but just agree with everyone and support the call and the call for the nation that we are mourning, but not as people without any hope. I sound like a pastor now.
You do, you do.
I'm a son of a pastor who would have turned 98 today.
Wow.
Who was born 2 years before Tati Nujoma.
Wow.
Who, just like Tati Nujoma, went also through the contract labor system. So it is in that context that talking today here is so profound for me. In fact, 5-6 years ago, I asked one of my former students, do me the favor and arrange a session. I just want to go and greet this big man. Because I've never really met him on a very personal level. So we are just saying, of course he was human, of course he was fallible, of course he made mistakes. But I took so much pride in the LGBTI community yesterday. There's a front page. I don't know whether that's true. And we know the utterances that Tati Nujoma made against the gay and lesbian community. But the front page of yesterday, we've forgiven you.
Thank you.
And for that we are saying, and I'm also saying, he was fallible, he was a human being, but we we say he deserved to rest in peace. And from my side, personally, that Nujoma rest in eternal peace.
Thank you so
deserve
much.
it.
Thank you, Dr. Nakuta. Madam, you have the brief final word this afternoon.
I am so honored to be sitting here today, not only as a legal practitioner, but as a black female legal practitioner. And that is something that could only happen within the constitutional dispensation we have. I am also proudly the great-granddaughter of a pastor who passed away at 101.
Wow.
And that was also only because of the constitutional and the environment that we are in today. I'm also the granddaughter of a fighter, a military fighter who was gunned down by Kufut members at the gate of my great-grandfather. So my grandfather's blood does not run in vain. And I'm so thankful that we have, or we had, or we were honored and in the presence of Dr. Sam Nujoma. And it is because of the foundation that he fought so relentlessly for, that my future children will then be able to benefit from.
That is so precious. Thank you for sharing that. Madam Angula, Dr. Nakuta, Ms. Jantjies, thank you for your time. Thank you for generously and altruistically sharing your expertise. Thank you for your role in building the Namibia that we all continue to aspire to. We appreciate you.
Thank you, Dan.
Thank you.
Thank you.
And that draws to a close this panel discussion that